I like starting things earlier on time so we can get done in a timely fashion and have room for your questions. So I'm going to talk for only a second and turn it over to some of the experts here. I'm Cathy Kaplan. I am not a cultural property expert, but a finance lawyer. So my fascination with being able to moderate this panel is the role that money plays in all of this, not only in fueling the activities, but in, frankly, creating the marketplaces that allow for people to want to steal cultural property and to, no matter how many controls are put in place, the fact that there still exists this flow of cultural property out of countries and into various marketplaces, private homes, collections, auctions, galleries, is really one of the things that we're going to talk about today. So without further ado, I'm going to turn it over to Jane, who, and again, everybody's bios are online, so I'm not going to regurgitate them. Jane is going to talk about some of the controls that exist and can exist around the flow into the market of cultural property. Then we're going to have some commentary on it, and then I'm going to throw in my thoughts on it and then ask all of you. We'd love to have questions from the audience. So with that, Jane.
Okay, thank you, Cathy. Before I get into my presentation, I just wanted to say, for those of you who were in the room during the lunch, or even those of you who were not, the board members of the Blue Shield were here, and anybody who wants to get involved, you can. There's no special prerequisite or qualifications. We have a sign-up list. Give us your email, and we'll be happy to send you some more information. So just wanted to make that clear. My remarks today are going to be informed by my experiences. I think Patty mentioned earlier in the day that I'm a lawyer. I was an assistant United States attorney in the Southern District of New York, here in Manhattan, for a wonderful decade, where I handled a number of art and cultural heritage-related cases. I spent 13 years heading up global compliance at Sotheby's, the art auction house. And I have been in private practice, and I'm now doing consulting in the art world. So I have kind of a 360 perspective on this, and just to let you know where I'm coming from. And to start, we heard this morning sort of a lot, maybe crushingly depressing rendition of how attacks on cultural heritage and art, can be part of and are being part of, intentional plans to destroy, eradicate, dominate the culture and spirit of people, of occupied people in armed conflict. But we also know from history that when cultural heritage and artistic sites and institutions are vulnerable in places of armed conflict and they're unprotected, that people opportunistically steal stuff to sell for profit. And we have a lot of historical examples of that, seeing a lot of stolen and looted cultural heritage from areas of armed conflict that end up on the market. We mentioned World War II, so massive amounts of Nazi stolen art that was sold to support the German war effort. Those works still appearing on the market today, nearly 100 years later. So we know that whether it's the works of art being stolen from the Ukrainian museums, or the Nubian artifacts that we heard about from Sudan, or the archaeological objects from Afghanistan, Iraq, Syria, elsewhere, those objects have appeared and they're going to appear on the market. We know this will happen in the next several decades. So what does the Hague Convention and its protocols tell us about this market problem? Not a lot. We heard Patty really talk in depth about it, but just to review, the main Hague Convention does have a general requirement that contracting parties, have an obligation to prevent theft from theft and pillage. And so, preventing theft could prevent it from going on the market. The first protocol adds to that, in addition to preventing the theft, preventing the exportation from an occupied territory. And there's also and Patty spoke about this, the requirement to gain custody and return objects that did escape from armed conflict areas. But neither the main convention or the first protocol have really any specific enforcement or regulation that would address the market. The second protocol, which is most known for tightening the military necessity provision, does contain actually a few more specific provisions that arguably address the market. There's a requirement to prepare inventories, and we heard, I think it was Fahim, talk about the lack of inventories in Afghanistan that, of course, inhibits the ability to trace things that are on the market, so there's that. There is also Article 9 of the second protocol requires parties to prohibit and prevent the illicit removal, export, and transfer of ownership. So there we're getting closer to, protection. And then last, the second protocol does require that the contracting parties enact domestic legislation that will criminalize violations of the second protocol, including criminalizing theft, pillage, or misappropriation, or acts of vandalism. However, while the second protocol, kind of is pushing closer to addressing the market, remember, the largest art market in the world, arguably the United States, has not ratified the second protocol or the first protocol. So we have a lack of provisions in the Hague Convention that really focus on the market, yet we have this indisputable problem that we know this stuff is going to end up on the market. So what can be done to prevent the inflow and facilitation of the illicit trade in cultural property in violation of the Hague Convention and in violation of many other international laws? Well, I don't have an answer, so I'm going to sit down. No. Okay, I do not have, the answer or the magic solution, but I've spent a lot of my career, and I believe very strongly in the power of voluntary compliance programs, compliance and ethics programs, to fill in gaps that are left open by the law, like the kind we have here. So what I'm going to try to do today is describe some essential attributes of a hypothetical perfect compliance program, and things that I think and I posit would greatly help mitigate the risk that the market is facilitating illicit trade. So just as a threshold matter, when I use the word market, I'm actually including not only the commercial actors, like the dealers and auction houses and galleries, but I mean to include everyone handling art collectors, museums, cultural institutions, who I think actually are part of the market, but just so you know, I'm not leaving out the not-for-profit cultural institutions. So just, compliance, I spent a lot of time working on compliance, and it's important for me to note that compliance is not the same thing as just obeying the law. Obeying the applicable law is, of course, a key component of any compliance program, but compliance and ethics programs involve establishing and enforcing standards and ethics that everyone in the organization, is expected to know and adhere to, even if those standards call for conduct that is above or more than what the law requires, more than the bare legal minimum. And so when we're dealing with a situation where we don't have specific concrete regulations, of the aftermarket in stolen objects, inculcating a culture of compliance around this conduct becomes even more important. So the first step that I would advocate, any organization, large or small, handling cultural heritage or art, in building an effective compliance program, is to conduct what we call a risk assessment. And what I mean by that is identifying and evaluating where you or your business or your organization is vulnerable. What is the likelihood that you will be handling certain kinds of cultural heritage, and what's the impact and severity of that? If you just sort of graft on a bunch of policies and controls without really analyzing where your risk is, your program is going to be designed to fail, in my opinion. So I think it's really important to talk to people in your organization, if it's large or even if it's small. Take a look at your business and ask, where am I vulnerable? What are the weaknesses? And have there been past problems that I need to learn lessons from? And what are my plans for the future, so that you know what to plan for? There's also a value in doing that and documenting that you did it, which is a trick that compliance people know, because just the fact that you thought about it is actually an important step to take should something go pear-shaped. You're in a better position to defend your conduct. Okay, so you've done your risk assessment. What's next? The guts, the core of any effective compliance program will be the policies and the procedures and controls. And one of the key policy areas, if not the key policy area for the art market, is going to center around due diligence. Diligence on the property, on the people, on the transactions. So let's start with the property. Compliance program will have to have a strong policy that sets out specific standards that concern what has to be done, what diligence has to be done relating to the property. And this may be obvious, but stolen cultural heritage and art is actually not that easy to detect. It doesn't look stolen. In fact, it looks a lot less illicit when it's in the hands of a museum or a dealer or a collector. So there has to be an intentional examination to find the problem. It's not just going to hit you in between the eyes. So the policy, in my opinion, has to first require an identification. What is this object? What is it? And where is it from? What is the country of origin or the likely countries of origin that the thing may have come from? When you're talking about archaeological material, that means what's the modern country or potential countries where it was first found? A lot of mistakes, intentional and negligent, get made in my experience at this stage. I can remember seeing things in my career that I was told come from Persia. What does that mean? One country is listed when really an expert will say in 5 seconds this could have been from any 3 of any countries, but one is picked because maybe it's less inflammatory. So you really need to focus on getting a good identification of what it is, and you need to consult with experts who know what they're doing. Either you have them on staff or you have access to them. That's just the start, figuring out what it is that you're handling. But to really know and form an analysis of if the thing is licit or illicit, your policy needs to require provenance research and substantiation. And by the way, this conference, we're addressing armed conflict, but what I'm saying will apply to address multiple art market risks, not just the armed conflict, but authenticity, other kinds of theft, fraud, smuggling. So you get a lot of bang for your buck when you enact a very robust provenance substantiation policy. So one question that comes up, how far back should the policy require the provenance to be substantiated? Now, first of all, the policy should state that. It should not be left vague. You should be telling people and be clear about what it is the policy requires. And the policy should also, in my opinion, define what are the kinds of evidence that will be acceptable to demonstrate what the provenance is. And, I think just one thing I'll notice that the market, has, particularly with respect to World War II, you can see how the market has recognized the need to document the provenance between 33 and 45. That's sort of been already absorbed into the way the market thinks. I think we're seeing at the upper end of the antiquities market, I don't think we're seeing it all the way, but the need, and the appreciation of the need to substantiate how long an object has been out of its country of origin. And I think, we're now, I think at a stage where we want I would posit the market needs to widen the lens to include armed conflict issues as well. So how far back should your policy require provenance? My view is the best policy is one that will require provenance substantiation to go back as far as possible. Archaeological objects, I believe, should be substantiated prior to the known date of that relevant nation's ownership, or some people call them vesting laws. I think for objects that, whether archaeological or fine art or otherwise, that are coming from areas that are known to have armed conflict issues, I think we need to require proof of legal export and import. I wanted to say a couple of words on 1970, because 1970 is a date that is held out and is included in a number of well-known provenance policies as a cutoff. And I don't want to go into too much depth because that's another conference in and of itself. But that date comes from the 1970 UNESCO Convention on the Means of Prohibiting and Preventing Illicit Import, Export, and Transfer or Ownership of Cultural Property, affectionately known as the 1970 UNESCO Convention. But we have to be careful with 1970 because it's not a legal standard. Okay, the date doesn't correspond to really any law in the U.S. It's also not that reliable. It's not completely reliable as an ethical standard either. You have to remember that some countries have export restrictions prior to 70. Many countries ratified, enacted domestic legislation later. But it also doesn't really correspond to anything in the Hague Convention or on conflict. And really most important, if you're thinking about archaeological material, ownership laws can predate or post-date 1970. So if you want to make sure you at least cover the bare legal minimum, 1970 may not get you there. So I think it can be useful as a buffer zone to have that, but I think in crafting a policy, would be careful not to just say, 1970, I'm done. So I like to say as far back as possible, and then, with these caveats. It mentioned import-export, and this is a really complicated area of the law, and I don't want to get too in the weeds, analyzing when they're enforceable or not, but I think it is essential for a compliance program to address and have a policy or provisions on import-export so that people know when they must obtain a valid export or import license for the object's movement. There are many laws. This is not relevant not just to the Hague Convention, so that it's not illegally removed from an area of armed conflict, but the United States has MOUs with 30-plus countries that have various import restrictions, so your policy must account for that. Okay, so moving on to what does it mean to substantiate or document provenance. I use the word substantiation rather than documentation because the way I think, probably from being a trial lawyer, is that documents are just one way you can prove a fact. And I like to put the emphasis in a policy and compliance more on obtaining credible, reliable, corroborated evidence to demonstrate and support each provenance entry. Right, so rather than on I have the piece of paper, and you need to think about what is the quality of the evidence that I have, and is it reliable? I'll throw in like non-documentary evidence actually can be quite probative. So it shouldn't be rejected out of hand. I just met someone who saw me testify a few weeks ago down in federal court at the Sotheby's Dmitry Rybolovlev trial. I was on the stand testifying about the compliance policies and program that I ran at Sotheby's. My verbal testimony was clearly credited by the jury and the judge, wasn't documentary, and I was used to prove certain facts. So if you have, statements that are relevant from third parties, for example, people who do not have an interest, what I mean is like a financial interest in the object, like not the consignor, not the seller or the buyer. And if those statements can verify credibly where an object was and when, and you can credit them, that can be used to corroborate a statement that comes from an interested party. So anyway, the emphasis to me should be on the credibility and the quality of the evidence that you have, not just on the pieces of paper. By the same token, I believe a policy should be clear that unverified, uncorroborated verbal statements that come from people who are interested, have a vested financial interest in the transaction, without more, shouldn't qualify as provenance substantiation. You should also be requiring in the policy that information is requested. And I don't say, that may sound very obvious, but that is, and Lucian probably can talk to that as well. In many quarters of the market, there's a reluctance to ask too many questions or make people give information, or they give you what they want to give you, and you're like, okay, I'm done. But to me, the provenance substantiation policy and process must involve chasing down and getting all information and conducting independent research, not just accepting what's given to you and calling it a day. Now, documents, of course, can be dispositive. They can be very useful, and they can actually help prove whether something is licit or illicit. If you get really good invoices, travel documents, personal photographs I have used to substantiate dates of things, publications, exhibition catalogs, all of those things, of course, can be incredibly helpful. But I also think the policy has to be clear that those documents that you do get have to be reviewed for authenticity, right? If they come and they're in different languages and you don't speak that language, you have to get it translated because you have to know what it says. This may seem obvious, doesn't always happen. There have been a lot of reported incidents and cases where, people have accepted fake forged documents to substantiate provenance and then, are caught up on that later. And I just want to note that while it is true that there are some fraudsters and criminal actors who are really good at forgery and can fool even the best of us, a lot of the incidents we read about, you kind of, when you read them, you're like, that could and should have been caught by a decent provenance review policy. So I just really wanted to bookmark that, you get the documents, make sure they're genuine. I think the policy also, and your program needs to establish who, and what I mean by that is also the role, not just by the name, but who in the organization is responsible and accountable for conducting the identification and the research and making the decision. So, and that's really important, right? Because compliance, if it's not, from top, middle, bottom, it tends then not to have much force in the organization. So I actually think the responsibilities for provenance accountability, substantiation accountability should be at a very senior level. And there needs to be an escalation path, right? People need to know, where do I go if I have a problem or a question? And sometimes, I'll just go out and say this, some of these issues can be serious enough that if you're at the kind of organization that has a board, they may be board level. So I think, putting them on the radar screen, having senior people accountable, having an escalation path is part of the compliance process. So what about exceptions to the policy? So generally, I'm of the view that like when a compliance policy is written to have, somewhere at the end, like a catch-all exception that like, well, even if you do all of this, the above, even if you kind of feel like there's a good reason, you could just still proceed. I think when you have that kind of thing, you basically created, an ineffective policy, right? You can't have a situation where the people who are responsible for doing the provenance research and substantiation also have the discretion to decide to proceed to handle an object, even if they don't satisfy the criteria. That's kind of like not really having a policy. Many companies, or programs, I should say, will have actually a policy on exceptions, because there needs to be flexibility, and some rules do have to be broken at some point, but that needs to be carefully crafted. Who in the organization has the ability to say, okay, we're going to make an exception on what grounds? And if it happens more than once in a blue moon, then the policy is effectively undermined. So I am not a fan of leaving in the loophole. I think that's a really problematic. I guess the bottom line here also for the market, and this is easy for me to say, wasn't always that easy to implement, but market participants have to be willing to walk away from an object. You have to be willing to decline to handle it when it doesn't satisfy these robust standards that you set up. Otherwise, again, it's a paper tiger, and it's not really compliance. Other steps in the compliance world that I'm not going to be able to outline all of them, but just to say that in addition to the written policy, a good, effective program is going to have what we like to call controls or processes, ways that sort of checkpoints or other ways to make sure that the policy is actually being followed. Lucian, Simmons, and I both worked at Sotheby's, and we can talk about this later, but we had something called the High Value Lot Review Committee. And basically, that was a way where we got a questionnaire filled out that had a lot of information about every lot, every object above $1.5 million that Sotheby's was taking in to sell. And Lucian and I and the general counsel, the three best people, smartest people in the company, we would review it and flag spot issues before they became issues. This is a form of a control to make sure that we had, an oversight. There were other things, but these will depend on what you do and the size of your organization, but that is another piece that I think needs to be in there. Okay, I'm going to move away from that's not all there is to be said about property, but just to move on to people due diligence, which is important in the art market as well, and it's a very big subject, and it's applicable to many other art market risks, particularly money laundering, but it's relevant to this conference and this discussion too. And I think I would say that you must have a good know your customer or know your client policy. You can note that law enforcement around the world, as its sights set on the art market, cultural heritage market, as susceptible to money laundering. Just the 2024 Treasury Department's National Money Laundering Risk Assessment just came out, and there's 2 little paragraphs mentioning the art market. UK market is regulated already. In the US, only the antiquities market is falling within the Bank Secrecy Act as a financial institution, which means it is regulated from an anti-money laundering perspective. So there's a lot of reasons for you to have this policy. And what is it designed to do? It's designed to make sure you know who are the human beings that you're dealing with, not just the court shell company, but who are the people, where do they reside, What do they do for income? What is their source of wealth? Who are the people? And these data points can reveal really relevant information that can help you to sort out whether what they're handling is licit or illicit, or from armed conflict areas or not. A good policy will note some red flags for people in the organization or people in your tiny organization. Something else I testified about downtown in the Sotheby's trial, there's a lot of questions about the red flags in the Sotheby's policy. And as I explained to the jury, the concept of having those is to get people to think about what are some circumstances that might be concerning, might be suspicious, that they should escalate and raise, okay? They may not be problems. Like a red flag may actually not turn out to be a problem, but if you don't raise it and explore it and know who to talk to about it, you will miss something really important. So some examples, is the customer client resisting disclosing basic identification information, like they refuse to give you a copy of their license? Odd. Are they asking, for very unusual confidentiality steps? And by that, I don't mean if they say, oh, I don't want my name in the press. Okay, that could be actually kind of ordinary. But if they say things like, please do not put my name anywhere in your internal books and records. I don't want anybody who comes to you to be able to find my name anywhere. So use this name. Okay, that's cause for further questioning. A basic Google search on people is something that should always be done. You'd be amazed at how few people actually do that. But is there publicly available information about the person that will, reveal questions about their trade practices, or are they under investigation? And then the last thing I'll just mention is, are they asking for, suggesting very strange payment arrangements? So please send proceeds of the sale to the following 10 different bank accounts in offshore locations. Okay, that's a crazy example, but you get the point. Or money's coming in from different locations, or there are third parties. Like, those are all reasons to ask more questions. They could be nothing, but they could also be signs that there's illegal trafficking and they're hiding what they're doing or where they're coming from or where they're getting and who's getting paid. I just, wanted to mention also, I'm sure a lot of people are thinking, oh yeah, well, that's all fine and good for Sotheby's to do, because the Sotheby's had, thousands of people all over the world, and you ran a whole department. But I do want to say that, the things I'm talking about, I believe are doable for small organizations. Yes, they will be proportional. That's the whole point of risk-based. So you're running a small gallery, you're not going to have a 15-person compliance department, of course. But you can achieve these goals with your resources. I just think it's important. I wanted to mention that I don't think we can see the market using size, or I'm small, I'm a big player, as an excuse not to engage in the compliance. A couple of other things. This is maybe more philosophical, but I can't help myself. But I believe that, for the art market to effectively police itself, implement good compliance standards, there has to be a change in attitude to think of compliance and ethics as part of the job, part of what it means to be in the market and do business. It's not, if it's positioned or thought of as like something extra, when I finish my real work, when I close the deal, then I'll get to the compliance. That, that's not going to work. So really, it's a recipe for failure. You have to have buy-in. You have to buy in from the top leadership all the way down, that this is how we do things around here. And it's just part of your job. It's not like, when you have time. And look, I'm repeating, but I'm understand there are varying sizes and different resources. Every organizations have different levels of resources available. The art market varies tremendously in size. We have people who are solo practitioners to gigantic museums or auction houses. But I think whatever size we're talking about, the compliance has to be thought of as a necessary cost of doing business. And whether it's time, money, resources, it just has to be factored in. And I'll just say, without elaborating, there have to be consequences for failure to comply. So that's just another basic compliance program. Okay, so then the last thing that I wanted to mention has to do with monitoring, audit, transparency. I know everyone really wants to hear a lot about auditing. So it's everyone's favorite subject. But it's an important piece of any compliance program, ongoing monitoring and measuring the effectiveness of what you're doing. So we in compliance have this expression, that it's not one and done. Oh, put the program up, policies are posted, let's get back to work. You have to take a look. And one of the ways you do that is you audit, which sounds very formal. And yes, you can bring in a Big Four accounting firm to do an audit, but you can also do an audit in-house. It doesn't need to be, a big outside consultant kind of thing. Basically, can you do a look back on all objects and transactions that in the past year that touch certain geographical areas where they're known for armed conflict? Like, take a look. Can you look at your interactions with certain types of objects or certain parts of your business? Can you audit your record of compliance with your own policies, which is something we did at Sotheby's. We would, have the auditors who are mostly looking at the financial stuff, also while they were in, take a look and audit, did this department comply with all the policies and report back on that. So I think a critical piece. And then, speaking of that, there's sort of an open question as to whether some members of the art market and community should be more public and transparent, perhaps about their auditing, but maybe about their entire compliance programs. And I think that's a complicated question, but I will say that in general, if it's possible to make compliance policies or codes of conduct available on the internet, I think that's a good thing. I think it's good to show the public and have the public able to see what the policies are that are in place. Your record, if you can reveal your record of compliance, it builds trust and credibility. It's not that easy for museums or commercial entities to open up their books and records to the public, so there's some concerns. But I think it's something that is really worth considering. I think the more public the market can be about compliance and ethics efforts and the record of compliance, the greater chance there is to kind of change attitudes. And so I'm going to leave it there, and then thank you for listening to me talk about my favorite subject, compliance.
Well, thank you, Jane. Thank you, Cathy, and thank you all for coming. I'm Lucian Simmons, and I'm the head of the restitution department at Sotheby's, based here in New York. Obviously, this is a very broad topic, and I can't speak for the art market as a whole. But what I can do is to give you my observations, because it occurred to me when I was on my way in today that I joined Sotheby's at a time when the 1954 Hague Convention was about to celebrate its 40th anniversary, and now we're at 70. So that's a 30-year arc. I actually joined Sotheby's at the time when the commercial art market was going through a profound change. I joined as a litigator in Sotheby's in London, and I was actually the first UK qualified lawyer to join our legal department. And immediately, we started addressing issues which have been around for a long time, but which have become more urgent as the company was becoming more international, such as allegations of money laundering by our clients, import-export, cultural property issues, and so on. And actually, it reminded me, as Jane was speaking just now, two of my earliest cases concerned Mr. Myatt, who was investigated by Scotland Yard because his trick was to forge modern British paintings, but also to forge the documentation supporting their authenticity, which he then placed in the archives of the Tate Gallery in London, so that when poor experts from Sotheby's and other auction houses went to check on the authenticity and check on the provenance, they'd find the corresponding record card fake for the painting fake. And I also worked on another case which concerned a massive collection of important photographs, which had actually been obtained through elder abuse from a nurse who persuaded an old lady to make over the photograph collection to them. And then the nurse and the nurse's boyfriend created an entirely fake provenance for the entire collection with faked photographs, daguerreotype photographs, a complete fake story that ran to 5 pages in our catalogue explaining where this wonderful collection came from. And again, the whole thing was made up. When in her introduction, Cathy mentioned that she's a finance lawyer and doesn't really necessarily focus on art issues. But it occurred to me that actually one of the main changes I've seen in the last 30 years is that art collectors are often now motivated not by the love of the art objects or by beauty or by wanting to create the best possible Italian Renaissance paintings collection. They're motivated by making purchases for investment. And actually, interestingly, that motivation, the motivation of investment, means that people want liquidity in their artworks. And if you want liquidity, then you want a painting that you can resell. So there's no point in buying a painting which has a problematic provenance or buying classical antiquity which you can't resell because it may not have any provenance at all, or you may suspect that it's come from a site in Sicily or somewhere else. In fact, that motivation of money, of profit on your purchase would drive the need to try and get a clear provenance and try to be diligent as you would if you were buying equities or investing in a company. And of course, that also applies to art funds, which are now quite common in our world, but again, 30 years ago were not so common, where there's a common ownership of shares in artworks bought as a collective, as an investment vehicle. And of course, I'm aware that the recent trial that Jane was alluding to, the Robert Lovelock trial, is an exception to this, where not everybody is always diligent. And another thing which is important to remember is that Sotheby's and our main competitors are usually selling as agent for consigners, whether they're individuals or corporates, and we're selling on often to other private collectors, or they're also to museums, which means that we are the fixed point in a chain of transactions, and we're the deep pocket that people see in the future. So there's a tremendous disincentive for Sotheby's, Christie's, and the others to sell stolen or problematic property, because 10 years, 20 years down the line, we will still be standing, but maybe the consigners have disappeared, and so we would be the people who'd be in the target for criminal or civil liability. The subject of this part of today is how should the art market respond to looting and thefts during art conflicts and natural disasters? And I think Jane gave the correct answer. How should we respond with diligence? For me, running our restitution department at Sotheby's, it's all about trying to work out whether there's risk to the company, to our sellers, or to our buyers from selling a particular artwork. And Jane also mentioned one of the major operations that Sotheby's put in place as part of our diligence program, which is the High Value Lock Committee. So every artwork worldwide, whether it's a diamond, whether it's a Basquiat, whether it's a rug, whether it's an oil master painting, goes to a group of multidisciplinary non-experts, so non-experts in art, so lawyers, compliance, and at one point scientific experts, to try and see if there's a risk that that particular artwork may be problematic. Not only the artwork, but also the consignor. So Jane mentioned that Google is an amazing tool. One of the things we'd often look for is not whether the artwork is stolen, but maybe whether the consignor or the person bringing the artwork to us for sale is going through a divorce, or is under investigation by the State Department, or is subject to sanctions. So all of those are things where we'd be looking to be diligent to protect not only the company, but also our buyers and our sellers. Because our experience, and my experience personally, is that a great way to lose a client is to expose them to litigation by selling them a stolen painting, by exposing them to litigation risk when they actually just thought they were trying to realize some money to build a new kitchen. So as I said at the beginning, my personal focus is World War II, which actually was one of the main, the aftermath of which was one of the main drivers for the 1954 convention. And my team's job is to reduce the risk that Sotheby's might accidentally sell a work of art that was looted in World War II, but was never later given back. And it's important that I say reduce the risk. This is a risk reduction program. We can't ever say, or can rarely say with certainty, that something wasn't stolen. All we can do is to say, we have gone through this procedure to reduce the risk. So cross-examine the client, say, what documentation do you have that this was really acquired from Wildenstein in Paris in 1935? If you say you inherited it, can you prove you inherited it from your late mother-in-law? We will also look in the catalogues raisonné, looking for authenticity, but also looking to see if an artwork has the provenance which makes us happy. And we'll also compare artworks against lists of losses from World War II, because this is focusing mostly on the Holocaust. And all of that is part of a voluntary compliance program of the kind that Jane was mentioning, and is designed to reduce risk. But the question then arises, what do we do if we find an indication that an artwork may have been looted, let's say from a Jewish family in occupied Europe in World War II? That's when we really go through the same procedure as we might if we were looking at a looted classical antiquity. We discuss internally what we think that risk is. Was this really stolen? And then, if there's no legal liability in doing so, we will make a full report to our consignor and say, look, we discovered this. Our recommendations are that we pursue these following next stages of research, which will often be going to outside experts, going to archives, and trying to work out if indeed there is a loss. And if there is an outstanding loss, if the artwork concerned had been looted from a Jewish family and never given back, then we would work with our consignor and often with their lawyers and their advisors to try and help reach a resolution, which may be the donation of that painting back to the original owners, maybe a sale with the proceeds split between the two sides, maybe a joint donation to a museum, any number of solutions which we try to help them reach together. I've already mentioned that our buyers are often much more focused on resale and the ability to realize their investment than they used to be. I can actually give you a good example of that from our recent sale season in New York. We were asked to sell a major Impressionist painting. I think the estimate was in the region of $20 to $30 million. This picture had been transacted many times in the private market and had been published in every major catalogue of the artist's works over the years. And actually it was interesting because the painting had a provenance back to the artist, but also the accepted provenance stated that it had been in the collection of a Jewish family who had lost it in World War II and had had it restituted to them after World War II. So everybody who looked at this said, oh, wow, this is a perfect provenance because this was clearly restituted. And I was looking at it with my colleagues and realized that actually there was a gap in the provenance. There was a gap because in 1936, the painting belonged to a lady with a Jewish name living in Germany. And then there's no sign of what happened to the painting until it landed up with a well-known dealer who traded with Nazi-looted art in Paris some years later, who then sold it to the Jewish family who lost it in Paris in the 1940s. So what I did in this case was to speak to the consignor and say, look, my job is to screen things and avoid liability for you, our client. We think that if we put this on the auction block, there could be an adverse inference drawn that this picture may have been looted. I'm not saying there's a legal claim, but I'm saying that you're leaving money on the table in not researching this and in taking away potential bidders in the auction sale. So can I please have permission to do these further research steps, such as sending somebody to the archives in the Musée d'Orsay in Paris, sending people to the Frick Art Library in New York, and lastly, going to the heirs of the family who we believe had this picture in 1936. And the client allowed us to do all those steps except for go with the family. And they came back with a nil return. And I said, look, we really, really should go to the family because we need to understand whether there's a risk that if we put this up, your interests could be damaged. And they said, absolutely, in that case, do it. So I resorted to Google. As Jane said, it's one of the best researchers' tools. Found the great-grandchildren of the lady who'd owned this picture in the 1930s, cold called them, managed to score a lunch with one of them here in New York City, and said, can you please give me the story of this painting? How did it leave your family's collection? And the answer was, well, the lady who had it in 1936 when she died in Germany had actually given it to her daughter. Her daughter didn't like the painting because it was rather vulgar, and the daughter preferred old master drawings. So it was sold to the dealer in Paris, who then sold it on to the person who had eventually lost it, which was fantastic. It meant we could go into the auction with our heads held high, telling this story. And then the buyer, after the sale, said, before I pay, and there's no legal obligation for me to do this, but he said, before I pay, can you please give me a report on all the work you did to confirm the provenance of this piece? So I typed up everything I just told you, and he said, well, I'd actually like you to present this to me in person. So the buyer turned up in Sotheby's offices here in New York City, and I had to go through every step of the provenance, standing in front of the painting. And then he said, I'm really happy now. Not only am I happy that I can pay and feel comfortable that I'm spending my money wisely, but also I'm now happy that I feel part of the continuum of ownership of this painting. And that's a long way since 30 years ago, because 30 years ago I deal with clients who, when they were consigning, would regularly take all the labels off the back of the painting. Now clients are much more focused and much more accepting of the importance of provenance. And that's one of my roles, and one of our team's roles at Sotheby's is actually to educate not only our colleagues, but also educate clients in asking questions and in trying to realize that provenance actually can increase value. So if you look at classical antiquity sold by Sotheby's, we have standards which Jane and her team set down some years ago, and pieces with an 18th century provenance or 19th century provenance sell incredibly strongly because people know that it's, if you like, an investment grade classical antiquity. Thank you so much. I love questions, but that's for later.
Hi, everybody. I'm Birgit Kurtz. I'm an attorney in New York, but I'm here in my capacity as co-chair of RAM. RAM is the Responsible Art Market Initiative, and Nick and I are co-chairs of the New York Regional Committee. The mission of RAM is to raise awareness amongst art businesses of risks faced by the art industry and provide practical guidance on establishing and implementing responsible practices to address those risks. So I think we are in the right place. First of all, thank you to Jane and to Lucian for this really comprehensive and thoughtful presentation, both presentations. There's really not much I can add. I mean, you're both superstars in this area, so I have very little to add. Just a few points. So we've heard risk assessment 1,000 times today. That's really where it starts. But it's good. It's a good thing. It's a good thing because then you go home and do you remember, what did I risk? Yes. So if you don't know what the risks are, you cannot mitigate them. And we heard it earlier today, the gentleman in Guatemala. He said they travel around and they do risk assessments. That's the only way you can mitigate your risk. And so even if it's not legally required, as Jane mentioned, the art market in the United States is currently not regulated like banks. But it's a good idea to do risk assessments anyway, and it's generally a good practice to have to manage your risk as a business. And that concerns all the risks that your business may face. So and Jane sort of mentioned it also, there are two aspects to a risk assessment. First is the likelihood of this bad thing that will happen, and the second one is the severity of the impact. You may come up with 50 risks, and then you're like, oh my God, how am I going to mitigate all these risks? You have to prioritize. How do you do that? You figure out what's really, where the impact is really severe, and it's kind of likely to happen. So those are the things you put at the top. That's where you put your attention. Where you put your money. So that's the first one, risk assessment. Second one, you mentioned not documentation. What did you call it? Substantiation. Yeah. But what I want to say is you document everything you do. Not the history of the stuff going back, but you document everything you do, even if there's a deal you rejected. Because when law enforcement comes to you, you can say, I had 50 potential deals, I rejected 20 of them because they were iffy. I only did 30. That'll speak for you if there's ever a question. You want to show law enforcement that you tried, that you did your best to avoid this bad thing, getting involved in someone else's criminal activities. The next one you mentioned, due diligence, very, very important. At RAM, it's a group, it's a non-profit in Switzerland, and a group of very smart people put together a bunch of really, really useful documents. One is the Art Transaction Due Diligence Toolkit. It's a bunch of checklists. They're free for you to get on the website, on our website, which is responsibleartmarket.org. And it gives you a bunch of checklists on the client, on the artwork, and on the transaction. Jane already mentioned these three things. So these are checklists, the questions you want to ask. There's lists of red flags. Remember, red flags are not a stop sign. They're wait a minute, ask more questions, get more documentation. You might still be able to go ahead, but you have to slow down a little bit. Those are red flags. So you have this due diligence toolkit. Everybody please get it. Then there is the Art Transaction Due Diligence Toolkit explanatory notes. Get those as well. And then finally, there is a new document specifically for the antiquities market, and that's what Nick will talk about in more detail. Thank you very much.
Thank you, Birgit and Lucian and Jane, and thank you all for coming. As Birgit mentioned, before RAM's annual conference last month in Geneva, we put together this sort of annex to the due diligence toolkit, which is among the materials that you've been provided. And what we wanted to do was try to connect all these things with relation to the antiquities market. And I don't need to go through all of them. I hope you will find it useful. To Jane's very good point, most of you are not Sotheby's. So there are ways to think about what you're doing. We did this for the purpose of helping all of you do that, with or without hiring experts like Jane or other advisors. I think Jane made a great point about one of the most important things you have the power to do is walk away. I'm a lawyer. I think this is something that lawyers often forget, but in fact, more so than the art market, we are indeed regulated by our rules of professional responsibility, and we are indeed bound to conduct ourselves in certain ways, which include not engaging in conduct which defrauds another person. If you help someone launder smuggled goods, you're not Atticus Finch, you're part of the problem. Not everybody deserves a lawyer, sorry. And even if they do, you don't have to be that lawyer. And so, because I think there are a lot of lawyers and lawyers in training in this room, it's your career too. So think about that. So again, I won't read all the guidelines out loud because I want to make sure we leave time for questions. But one of the things we spent a lot of time talking about in putting together this guidance is use your diligence processes as a way to add to the state of information. Right? Don't think about this. Don't think about what you know and what you've investigated as a document that you edit and save over itself. Make a record of what you know and what you found out and the questions you've asked, and then update it with what you learned, but keep what you learned before. Other than a famous episode of The Wire, innocent people, don't act like they're engaged in criminal conspiracies. Keep notes. That's a good thing. Don't act as though you're doing something wrong when you're not. Act as though you're being thorough and showing your work. So a lot of the things that we talked about, but some examples to keep in mind are suspiciously low prices or prices out of line with the market segment. Seller intermediary who has been reported frequently in connection with unauthorized excavation or cultural property sales. Again, that's a red flag that might prompt further inquiry that might turn out to not be anything illicit. But if you've seen a name a bunch of times in connection with a certain kind of issue, a certain kind of problem, make sure you satisfy yourself. If it's an antiquity or something that might have a connection to a zone of armed conflict, if it's presented with very limited or no documentation or provenance or substantiation, contradictory or inconsistent information, documentation that appears to be false. We've heard this a number of times here today. Documentation itself can be the problem. It's not an antiquity, it's not an armed conflict, but as many of you may remember, this is almost 15 years ago now, but the famous Beltracci forgery in Germany was so devious because he went to this trouble of creating this fictional collection and these fictional old sepia tone photographs and everything else. Determined fraudsters will do their thing, but just don't assume a particular kind of information is always unimpeachable. Clearly relevant to today's topics, indication of a recent presence in an active conflict zone where excavation or export permission would have been unlikely under the circumstances, and payment requests in currency or jurisdictions with no apparent connection to the transaction. A lot of things you've heard today. Yeah, so I think these points, I don't need to belabor the point that you've heard from so many people here today, but your diligence can be part of the solution to many of the things that have been raised here today. I am an advisor to people in the art market. I'm an attorney. I represent collectors and dealers, and galleries, and sometimes auction houses. And we can wag our fingers at the market and say it's the problem and it's no good and it's got, it's a source of trouble. But that's not going to help or really fix much. The regulatory scheme is really a lot less useful than the concepts we're talking about here today. The regulatory scheme here in the United States, this is my opinion, is totally incoherent. Antiquities dealers are not banks. And that is the only manner in which they are regulated, and they are regulated for the trade in objects for a term that is still undefined in the statute that was passed 4 years ago. That's a rule of law problem. Whatever you think of the issue, even if you think antiquities dealers should be put out of business, from the standpoint of predictability, if all you're trying to do is comply with the law, it's actually not that hard to meet that minimum threshold, and that will both expose you to further reputational and ethical risk, and it will itself perpetuate a lot of the trade and conflict objects that we're talking about here today, because it's not that hard to comply with some of those things, and if you merely comply, you might not go to this extra inquiry that we're all talking about here today, which all of you should do, all of you should want to do, and which I am a believer, my opinion only, the market can be a powerful force in improving those things. So I'll leave it there, thank you, and hopefully we'll have some time for discussion.
Thank you. So I want to take questions, but Nick, I want to pick up on one thing you said about regulation. And, in my finance, I work a lot with financing for art and art institutions at Lucian, the kind of having done 2 financings for Sotheby's at the very highest level. And then you can do due diligence. You're talking about objects, your objects in the 1.5 million. But the problem I see with all of this is that there's a lot of market way below that, which goes to your point about regulation. And the art market is a wildly unregulated market. And the fact that I could say I'm a dealer in pre-Columbian Guatemalan antiquities, go open a store, create a fake Wikipedia page, any one of you could come buy from me based on my Wikipedia page. And that's it. And those are cheaper objects, but my point being, there's a huge flow of objects way below the Sotheby's and other reputable institutions where there's no regulation of who's selling and buying them. And they're on some cases, there's actually no ability to really put due diligence into place because there's no consultation with lawyers or experts. And I've seen many people, even smart people, who put themselves out as dealers because they have some knowledge of objects with really not the resources or the time or the energy or the desire to have the knowledge and the respectability. And I think that's an ongoing problem for the industry, because that allows for the continuous flow, because if there are people willing to sell and people willing to buy, you've got a problem. And that's not even talking about the criminal element that is taking things and parking them somewhere for, and another facet, which is a very different conversation, not for here, is the role of cultural institutions. And, again, it would seem to me that any museum, if you start getting stuff in from Afghanistan, is going to, some feelers are going to go up. But the idea of what's in collections, how they've been gotten, is obviously a lot of the what museums and cultural institutions are going through now. And a lot of cultural institutions with boards have to face up to how you deal with a collection donated by somebody who's given you $2 million. They hand you a collection. Can you take each object and check its provenance? And those are, I know the right answer, but those are very hard questions to deal with. So anyway, that's just to throw some other thoughts into the conversation. Questions in the room?
So since this is relating to the Hague Convention, this conversation about the market, and to set the standards for due diligence, what lens should have primacy? Authenticity, stewardship, fiduciary, legal, or the communities that lost this cultural property because of instability and conflict? Who has, if you build these standards, what it should be set to? Is it for the client? Is it you don't set enough standards so you don't go to court? Or because a lot of this material was gained because of war? Where should it sit? What lens?
That's a good question. Well, all of the above, actually. And I think the way, except for the way you mentioned something like not going to court. So, I don't think a compliance and ethics program should be about, let's just, protect ourselves from getting caught. That's not. But all the things you mentioned, I think, overlap, right? The interest of a culture, of a nation, of a community is implicated by the Hague Convention, by national ownership laws, by import-export laws, right? By the 1970 Convention. So they're overlapping. They're different. They're slightly different, but they kind of are all converging around, I think, similar values and meanings that are achieved by the policy. Authenticity may sound a lot like it's only about the market value, but, and I know Patty Gerstenwith could speak more eloquently about this, but I can speak about it too because I believe it. But the record of authenticity or a fake record of authenticity of the archaeological record damages what we know about the culture, and it causes external harm in the same ways that pillage from armed conflict areas does. So it has larger implications than just, darn, I spent a lot of money on that and it's fake. So, I think at some point these all converge. It's very, very similar goals and values of keeping the market, with integrity. I don't know, maybe.
I would also add, sorry, go ahead.
Just one additional point. I think the idea is not to buy looted art, not to buy smuggled art, so that there's no market for it and there's less looting, ideally, right? So you would just strangle a market and there's no incentive for these people to loot anymore.
And I was just going to say, I think what I find productive is an intersection of those things. I think in the real world, you have to be aware of people's self-interest and what's going to motivate that and appeal to that. But I believe, with the benefit of some experience, that most people want to do the right thing. And I have often found that when I educate people about what their legal rights are, and it is often the case that they are on very firm ground legally, because a lot of these things are difficult to enforce or litigate for lots of reasons, they still want to ask more. They still want to know more about the communities involved, about the artifacts and the situation. And they are often motivated to bridge that gap voluntarily, maybe from the security of understanding their rights better. But I think you have to draw people out and give them a reason. Not only assume that people are going to do the most altruistic things at all times, but to give them a permission structure and a space to do it.
And in general, my mantra is forego the short-term profit for the long-term success. So even if if it's a great thing right now, look at the long-term problems or success that you're facing. It's always think of the long term.
And actually, I'll add one more thing, which is give people credit when they do the right thing, right? It's easy to complain. It's easy to say this group or that segment never does enough, or they don't care. A lot of people care a lot, and a lot of people spend a lot of time and their resources trying to do better. And it goes a long way to encourage other people to do that when that's rewarded.
Hi, good afternoon. My name is Helena Arrows, and I work for the Antiquities Coalition. We focus a lot on looting and trafficking of antiquities, and I really appreciate all of you today coming to speak on this. It's great to hear about these initiatives. And we have also, for a long time, appreciated the Responsible Art Markets guidelines to help with anti-money laundering regulation and the guidelines that major auction houses have self-implemented to try to combat these crimes. But despite this, we're still seeing some pretty high-profile cases of things like sanctions evasion and money laundering, even as recently as this year, especially with the conflict going on in Ukraine. So I'd like to ask you all, what kinds of regulations or steps would you recommend to continue to try to fight these types of crimes that are existing and being facilitated through the market? And I definitely take your point that antiquities dealers are not banks, but we're seeing similar types of regulation on things like jewelry stores and pawn shops, which are maybe a better analogy. So welcome your thoughts, and again, thank you all so much.
Well, yeah, I mean, I have some view on the money laundering and sanctions. First of all, on the sanctions, the sanctions checking is very doable. It's you have to run names against a database, and I think that certainly most of the larger players are doing that, and it's also for smaller players doable. And I guess one thing I would question is, while there is definitely a lot of media attention to one or two cases, I actually don't think that there is an abundance of evidence that there's sanctions violations going on in the art market. I think if you take a look, there have been one or two cases. There's one in last year, but there really haven't been that many. That's just I think there's a lot more talk about it than reality. And look, the money laundering, I think there's also people, I'm a former federal prosecutor, so when I think of money laundering, I think very precisely about the legal definition, and I think a lot of people collapse predicate crimes and just call every crime a money laundering crime, and that's actually not accurate. Money laundering is in itself a crime. It's not, you commit the predicate crime, and then when you engage in a financial transaction to hide, conceal the funds, then that is a separate crime. And that is not, the art market isn't as hospitable for that as I think many would like to make out. It's not that easy to come and say, hey, I have cash. that I've derived from healthcare fraud or human smuggling. So I'm going to go talk to Lucian Simmons and say, I have $5 million in cash rolled up in a suitcase, so can I pull up to the dock and give that to you and you'll give me a Picasso? It's just, no, you're going to have to go through the financial system. And then that's the first line of attack, the banks. So anyway, that's just my spiel on that. It is not to say, and I did say, that the art market should have robust AML policies and should have know your client. And I think having that has kept Sotheby's out of a lot of trouble over the years. So I'm not saying not your problem, don't think about it. I just think, to be realistic about what we're talking about.
Yeah, I agree completely. The only thing I'd add is that art is a very bad vehicle for laundering because artworks are by definition very identifiable, and they're online and you can search for them. So that they're not that liquid. They're not that easy to hide things in.
I would also add maybe to your, I think, to the concerns behind your question. This is a philosophical place that we all have to land as to whether it's a regulatory question or not. As I was trying to allude to, I think there's a lot of space between regulations where meaningful progress is possible, not because of the regulations. Like I said, you could be, even if the antiquities regulation now applicable had the version applicable to the entire market had passed, realistically, how many people are getting $10,000 in cash anymore and either reporting it or not, right? The point is, in 2024, if somebody walks into your business of any sort with $10,001 in cash, you should say, "Good day, sir," whether or not it's an antiquity. And I don't mean to be glib, but the point is, because I think a lot of the resources are accessible, the OFAC database is very usable, for example. I think a lot of people don't know that, right? You don't have to have somebody as sophisticated or experienced as Jane or Sotheby's legal department or Lucian to probe a variety of very sophisticated resources that are easily searchable. But a lot of people think that you do, and they sort of are afraid to dip their toe into it. And I think you and the Antiquities Coalition do a great job of this, and I think that part of the information and education is really important, and I mean that, and that's why I think it's more useful as a kind of a market crowdsourcing-based solution. People could disagree, but I think you can lead people there with the tools we have to work with.
But isn't one of the questions on tools even where you have traditionally not had a lot of contracts that allocate responsibility to the seller of objects of art? One of the things is if you put yourself out there and do the research and perhaps represent something as valid, you are opening yourself up. You are more likely than to be sued if you do what has been done for years by everybody on the sell side, which is say, buyer beware, you're getting what you're getting, good luck.
Well, needless to say, everyone should hire a lawyer for their contracts. But kidding aside, it doesn't have to be that complicated. Those allocations of risk and responsibility in a commercial transaction absolutely should be explicit. And you don't need a 14-page contract to do it. You need a summary of business terms.
But my only point is that the art market for years has not worked that the seller, whether it's an auction house or a gallery, takes, quote, responsibility for vetting the objects they sell.
Right.
And that is part of, I understand why that is, and I've certainly represented the sell side, but that is part of the problem.
Yeah.
Anyway, do we have more questions? Because I know all right, I see one more, and then we'll. Great.
This is Perry McGowan out of Minneapolis. And to further go down this rabbit hole, if we talk about items appearing at auction and there may be $50,000 or less, maybe a few hundred to a few tens of thousands, as a buyer, what should the buyer expect from the auctioneer in terms of provenance and the quality of that provenance? With the rise of the internet over the last 25 years, there's been a massive movement of auction activity onto the internet. It's a much more global action today. and yet the function of the auctioneer to hit the hammer down on the table hasn't changed a lot, at least at the lower end of the market. So I'd appreciate any comments.
Well, so Sotheby's has a minimum lot threshold, which is a little higher than $200. But basically, ask questions. Any auctioneer should be able to answer the question of where did it come from. Whether it's on eBay or Etsy or anywhere else, you can ask questions. And you should ask questions. And so, again, I mentioned earlier, I was answering questions on a massively expensive Impressionist painting. We also answer questions on pieces of porcelain and things which are way lower in price. So it's always ask questions.
I mean, I'll just add, that's true, but I also think, and maybe this is part of what I was trying to say, I believe the market, shouldn't behave in a way that is like, well, we're going to put this out there, and if somebody asks us a tough question, we'll pull it away, we'll take it down. That's reactive compliance. So you're asking, like, what should you be able to expect in an ideal world? I think, whether it's a big player or eBay or a small player, or when Cathy opens her website and becomes a pre-Columbian dealer, where we need to get to is a place where the expectation is that there's been a compliance program, there's been some vetting. And should there be evidence of that when you look at the entry? Probably, right? You should come where there's an expectation that I'm going to see some provenance and identification, whether it's a small antiquity of low value or whatever it is. That's ideally where we need to get. Now, what is the incentive to get there? That's I don't have the right answer for that. But I think we do need to change the attitude. And it's not good enough in my view to say, I'm just going to put it up there, and don't worry, if we get caught, we're going to pull that right down.
If I may add,
It's sold and it's introduced into the market, and that's the opposite of compliance.
yeah. So it's a matter of your risk appetite. If you see a Picasso on eBay for $500, buy it if you want to take that risk. If you don't, then don't. So everybody has a different risk appetite, right? And so you figure out what is yours.
But, listen to that voice in your head if you have questions, right? I mean, if you are looking at something at Sotheby's, I can tell you, not just because I like him, that Lucian's done his homework, right? I can also tell you that if you ask him a serious question, he will give you a serious answer, right? As will other people that I could list. If it's someone you don't know or I don't know, and you ask a question, pay attention to the manner in which it is answered or not answered.
All right, well, on that note, Pippa keeps looking at me and saying,